Thank you very much, Nania. Good afternoon once again to our attendees. Good afternoon to my co-panelists and to everyone joining us. I wish to take it off from where Nania ended, that the whole arbitration proceedings start from the arbitration clause. Now, for the benefit of our attendees who may not be too familiar with arbitration practice, and ADR in general, by way of introduction, I wish to say that arbitration is one of the processes of what we call alternative dispute resolution, where parties to an agreement will decide that in the event of a dispute, they will not resort to court. So the term alternative dispute resolution is an umbrella term that looks at a broad spectrum of processes that involve resolution other than through the courts. Now, arbitration is one of such methods of ADR. Now, at the heart of ADR is what we call party autonomy. Now, party autonomy means, among other things, that the parties determine how the procedure for resolving their disputes through one of the methods of ADR. So in this case, we're going to focus on arbitration. So for the purpose of this presentation, by party autonomy means that parties are free to determine, first of all, who will be the arbitrator, where to have the arbitration, which rules will govern the arbitration. And so parties also invariably draft that arbitration clause to spell out the terms of the arbitration proceedings for them. And that is why it's very imperative to avoid as much as possible pathological clauses. Now, for this presentation, let me put out there that one of the peculiarities of arbitration is that unlike the other modes of dispute resolution, for instance, mediation, where a mediator only facilitates the process, the arbitrator, in fact, conducts what we call a judicial hearing, akin to a judge listening to both sides, the evidence, and then arriving at a determination which we call an award, which usually is final and binding on the parties. Now, because of the outcome of arbitration that be final and binding on parties, it's imperative that parties be careful to avoid pathology in the clauses that will govern the arbitration clause. So my presentation, we really look at what we call, it's been said that it's very difficult to define what a good arbitration clause is, but it's not as difficult to know how a bad one looks like. So in fact, let me issue this caveat now and then that there may not be one clause that fits all kinds of situations. The most important thing is for parties to be aware of what they expect out of the contract and how they intend to resolve the dispute. So what I'm seeking here to do is to point out the pathological clauses that as much as possible contracting parties should avoid, and also give some guidelines. So as I go through some of the clauses that you should try and avoid, I'll give you examples. Then these examples have been taken from actual agreements of parties so that we don't fall into the same pitfall. And finally, at the end of the presentation, I will set out recommended arbitration clauses for parties to adopt to suit the circumstance of each case. So by way of introduction, as I explained, arbitration is supposed to be a tool for helping parties to resolve their disputes. And so we should try as much as possible to avoid coming up with an arbitration clause, which in itself ends up in dispute. Now, experience has shown that sometimes because of a defective arbitration clause, parties can fight over the meaning of that arbitration clause because it is pathological and can spend time and money going back and forth in court over the meaning of an arbitral clause. And usually when they end up resolving the dispute, realize that the hearing of the arbitration itself may take relatively shorter period to do it. So the agreement to arbitrate, which is the arbitration clause, should not in itself be couched in a way in which there will be a dispute, because one contracting party understands the clause from a different perspective. Now, in giving out my presentation, I've sought to set out a few guidelines from writers like John Townsend, who talks about what we call avoiding the 7 deadly sins in arbitration clauses, and which I'm going to explain, and then I'll look at other clauses too. So by way of concluding the introduction, the aim of an arbitration clause is to resolve a dispute and not to create one by the very arbitration. Now let's look at what is the effect of a pathological arbitration clause. Why do we, as much as possible, have to avoid pathological clauses. There are various reasons. Now, contracting parties will put themselves at the risk of interpretation by the courts in determining what this clause actually means, who is to determine which particular matter. I'll give you very practical examples as we go on. And of course, even fighting over the meaning of pathological clauses in itself costs money and time before you actually come to the hearing. It also may have reputational damage if you are an arbitration practitioner, or if you help to draft the arbitration clause. It also may have reputational damage for such a drafter, considering that by reason of your inattention or omission to include certain terms in the arbitration clauses, parties have actually ended up going back to court to seek an interpretation of that pathological clause when it was the very thing they tried to avoid, and that is why they resorted or they agreed to go to arbitration. Now, having said that, let's jump into what is a pathological clause. Various definitions have been given on what's a pathological arbitration clause. According to Sherman and Bennett, they define a pathological arbitration clause. And can you see my screen? I'm just wondering if everybody can. Okay. So pathological arbitration clauses include clauses that are impossible or extremely difficult to implement, or clauses that are likely to breed disagreement or likely to invite challenges because of over-lawyering. There was too little foresight on omission in the way the clause was drafted. Now, our Dr. Bishop also defines pathological arbitration clause as a clause that is drafted in a way that the clause may lead to disputes over the interpretation of the arbitration agreement, or may result in the failure of the arbitral clause in itself, or may result in the unenforceability of an award. Assuming an interpretation is given to the arbitration clause to enforce arbitration, you may still have an issue at the stage of enforcement due to the pathological nature of it, where the enforcement tribunal is of the opinion that the arbitral tribunal was not properly constituted or did not have jurisdiction. That is why it's important that even if you're able to surmount the difficulties with the interpretation, you may still come back to that difficulties at the stage of enforcement. Now, let's quickly go on. I am aware I have just about 30 minutes to discuss these 7 deadly sins. The first sin of pathological clause, as I've stated, I'm here to tell you the ones you should avoid because it's easier to talk about those ones and then give you a guidelines on recommended clauses. The first sin you want to avoid in drafting your arbitration clause is what we call the sin of equivocation. According to Townsend, this is a sin where parties fail to clearly state out what they want, whether they want to go to arbitration, whether they want to go to any other form of ADR, or even whether they want to go to court. Now, when you have such an example of an arbitration clause in your agreement, it's not clear whether you're going to arbitration or option. Let's take a look at some few examples that I have here. So the first one, the arbitration. Now, again, let me point out here that the arbitration clause may be part of the contract itself as one of the clauses, or it may be set out in a separate agreement itself, which you call the arbitration agreement. Either way, the guidelines that we're putting out here applies to whether it is an arbitration clause within a contract in itself, or it is a separate document called an arbitration agreement, which relates to a contract that has been entered into between parties. Again, the reason why we advise you to avoid this is that before the contract is executed, when everything is sunny and optimistic among parties, it is easier to arrive at an agreement than when the dispute arises, because then different interpretations are put on and you may not be able to agree, or if you do, it take a while. So let's see this example. It says that the court of Ghana shall have exclusive jurisdiction to resolve all disputes arising out of this agreement. I've seen this in an agreement before. It was a commercial agreement. And then one of the clauses, let's say clause 10 said, the court of Ghana shall have exclusive jurisdiction to resolve all disputes arising out of this agreement. Then you go further down the agreement, getting to the end of the contract, you see another clause that says, parties shall resolve all disputes arising out of this agreement through arbitration in accordance with the rules of the Ghana ADR Hub. So the question is, in one clause, you are setting out that the dispute will be resolved. I mean, the Ghana courts will have jurisdiction to deal with the dispute. In another clause, you're saying that parties will resolve the dispute through arbitration. This is what we call equivocation or ambiguity. It is not clear whether you want to go to the courts or you want to go to arbitration. having such a clause is what we call the equivocal clause in arbitration clause, which you want to avoid. Now, a second example I have on the screen. So after I talked about the pattern, I'll give you the recommended one. The second example, it says that in the case of disputes, the party shall submit the dispute to the Ghana ADR Hub. Now, if you look at it, you might think that this is a good clause, but it is pathological in the sense that the Ghana ADR Hub, for instance, is noted for providing service not just in arbitration, but in mediation as well, and other dispute design method systems. So when you say that the party shall submit the dispute to arbitration, to the Ghana ADR Hub without stating which type of dispute resolution mechanism you are opting for, this is equivocal. It is not so clear. It is not forthright specifically that we shall resolve our disputes through arbitration, because if the other party says, well, I did not anticipate that we'll go to arbitration, I was thinking of mediation. So here you are saddled with this issue of interpretation, whether this second clause in fact meant that you go to arbitration or you go to another. So you want to avoid such clause. A few more examples. Let's look at the first one. It says that in case of dispute, the parties undertake to submit to arbitration, but in case of litigation, the commercial division of the High Court shall have exclusive jurisdiction. Now you look at this clause, and the first thing you ask yourself is, do parties intend to go to either the commercial court or to go to arbitrations? Which is which? It is equivocal. Another one is that in the case of disputes, the party shall submit the dispute to arbitration. If arbitration fails, then party shall resort to court. Now there is so much ambiguity in these clauses that I've shown. Clearly what runs through these pathological clauses is that parties have not unambiguously set out that they want to go to arbitration. So you should avoid the sin of equivocation, which is neither here or there, not setting out exactly that you want to go to arbitration. Now, it has been argued that sometimes when you have such equivocal arbitration clauses in your agreement, the courts are largely inclined to give an interpretation that enforces the arbitration, the intention to go to arbitration. But others may say that, well, it appears you wanted to go to commercial court, so I'm not going to compel the other party to go to arbitration. The thing is, why leave it? Why put it at the risk of the judge deciding what interpretation should be put on it? That is why you need to avoid the sin of equivocation. Now, the second sin in drafting arbitration clause that I wish to talk about, again, according to Townsend, is the sin of inattention. In fact, everything that I'm going to talk about, all the bad examples I'm going to give, is largely due to ignorance and, of course, inattention. So you will have, for instance, a domestic arbitration, which is not an investor dispute resolution, and then they have probably copied and pasted the template the contracting party saw somewhere on arbitration and have inserted into the agreement. And as I sounded the caveat at the beginning, an arbitration clause should suit the needs, the business of the parties, what they intend to do and the outcome. So you need to be careful. I think it is very bad on you as a drafter to say, oh my God, I never really paid attention to the dispute resolution clause. So the sin of inattention must, as much as possible, be avoided. So on this score, I say, when you are adopting template clauses, that is copy and paste clauses from people's agreements or online, wherever you may be, please avert your mind to the transaction it relates. That is your transaction. It is a great sin which may never be forgiven that I did not watch out for the arbitration clause. Now, the second sin, the third sin, is what we call the sin of omission. So basically, this involves contracting parties omitting very crucial elements from the arbitration agreement. This is one sin that I've seen over and over again in most agreements. So you have, for instance, the parties agree that any disputes arising out of this agreement shall be resolved by binding arbitration. And that is just it. Now, I've read an article that said she read an agreement made up of about 40 pages of a commercial agreement, only to find at the end of the last page, this clause there, and which ended up in what he calls the hell of arbitration. In fact, eroding all the gains of arbitration, because clearly here, even though you have to go to arbitration, you have not determined which rules you are going to apply to the proceedings, the arbitration proceedings. Here, people may either resort to going for what we call an ad hoc arbitration, which is where they administer, the contracting parties with the help of their own solicitor or themselves, administer the arbitration proceedings, or to use an arbitration institution, arbitral institution like the Ghana ADR Hub, the Ghana Arbitration Center, LCIA, MCIArb, AAA. There are various arbitral institutions out there. So if you say you resolve your dispute through binding arbitration, the question is where, how? So the sin of omission, while this clause indicates parties' intention to resolve the dispute out of arbitration, does not take the dispute out of court. For instance, who will be the arbitrator? How will they be selected? Will it be a sole arbitrator, or there will be a panel of arbitrators? All these issues can lend itself to arguments and disagreements. That is why it is important to avoid it. One will say, I wanted a sole arbitrator. One said, because of the complexity of the case or the amount involved, I wanted 3 arbitrators. But at that point, you realize that clearly looking at this clause, you do not state whether you want a sole arbitrator or a panel of 3. You did not state, for instance, where the seat of arbitration will be, so that by choosing the seat is the court of that place, which will determine procedural issues. You've not decided the language, for instance, assuming it's an international arbitration. You've not decided the substantive law that will apply to the arbitration, especially when it's international arbitration. And everyone wants to use their own national laws as the applicable law, which then runs into a lot of disagreement. So again, the sin of omission is something you want to avoid. Now, a converse of this sin of omission is the sin of overspecificity. Because somebody has read somewhere that you need to be specific, spell out everything you want to see in the arbitration clause. You should be very specific. Now, sometimes they go ahead to be over-specific, and over-specific makes the arbitration clause almost you can't implement it. So let's look at an example of a sin of over-specificity. It says that the arbitration shall be conducted by 3 arbitrators, each of whom shall be fluent in French and Arabic, and shall have 20 or more years of experience in the practice of law and engineering, and one of whom shall act as chairman shall be an expert on the law of negligence under both common law and civil law. In trying to cover all ground, sometimes you can commit the sin of over-specificity. Now, what I've put out on the slide, I said, good luck with finding an arbitrator who fits this description. You know, because it's a construction agreement, you want somebody who's probably done civil engineering for 10 years, at the same time speaks Spanish. You know, you're just so over-specific that it almost makes it impossible to get an arbitrator who fits this kind of description. So while I'm asking you not to omit very relevant terms that regulate the agreement, I'm also saying that do not go overboard to be over-specific with the arbitration clause. Now, the other sin that you should avoid as much as possible is the sin of unrealistic expectations. According to Townsend, the companion to the sin of overspecificity is the sin of unrealistic expectation. And this usually involves fixing unrealistic and tight time limitation. Of course, arbitration has been touted in various circles as being cost-effective, as speedy, and etc. And because you want to prove that indeed arbitration is fast and speedy, you have very timelines that cannot be unmet. And the issue is, so you give an arbitrator, for instance, 7 days to come up with an award after the hearing. So if the 7 days lapses and he's not been able to give an award, does he now not have jurisdiction? So you want to avoid putting the arbitrators in very tight, and even the parties in tight expectation. Let's look at an example of an arbitration clause which is unrealistic, has unrealistic expectations. The first one says that the claimant will name its arbitrator when it commences the proceeding. That is the claimant, the person who initiates the proceedings at the arbitration process. Then the respondent will name its arbitrator within 7 days. And the two so named will name the third party who will act as chair within 7 days of the selection of the second arbitrator. Hearing should commence within 15 days of the selection of the arbitrator and will conclude no more than 3 days. The arbitrator should issue the award within 7 days of the Constitution. You know, very airtight clause like this. I mean, the whole idea, if you look at it, is to ensure that the proceedings moves as fast as it could be, but you need to be careful that they not end up in being unrealistic on its own. So what is the takeaway from this? It says that arbitration is indeed supposed to be fast and cost effective, but please get real. Now, usually the arbitration rules of the chosen, arbitral institution should work, you should use it. For instance, you can adopt the arbitration rules of the Ghana ADR Hub, of LCIA, of MCIArb, Chartered Institute of Arbitrators. Most arbitral institutions have come up with very thorough, elaborate rules that deal with some of these issues, which balances the need to have an effective, speedy resolution through arbitration, while also balancing that with the need of parties' expectation in it. So again, when I come to the recommended clause, you see how to deal with this. So time limits are important indeed, but please avoid squeezing yourself into unrealistic expectations as you draft your arbitral clause. Now, the other sin you also want to avoid is the sin that Townsend classifies as the litigation envy clause. That is the Lot's wife scenario. You know, for those of you who have been in litigation for so many years, sometimes winning yourself off into arbitration, you carry with you some of the attributes of litigation, and you tend not to cut some of these attributes of litigation from yourself. So you find, for instance, an arbitration clause saying that the arbitration will be conducted in accordance with the High Court civil procedure rules applicable in, let's say, the US or the High Court of Ghana, and the arbitrator shall follow the Evidence Act, for instance, of Ghana, or the evidence rule of evidence. Of course, the very reason why parties usually opted for ADR in general and arbitration specifically is to avoid some of these technicalities and the uptight rules and to allow some little bit of flexibility. So litigation envy clauses are those clauses that are they are leaving litigation behind, but are dragging some aspects of litigation back into arbitration. You end up almost facing the very challenges we are trying to avoid in the first place by resorting to arbitration instead of litigation. Another example of a litigation envy: the arbitration will be conducted in accordance with the High Court civil procedure rules of Ghana, and the arbitrators shall follow the rules under the Evidence Act. So yes, we are going to arbitration, all right, but we want our arbitrator to follow litigation rules on evidence and not procedural law. Now, the final sin I wish to talk about is the sin of overreaching. So you have an arbitration clause drafted in a way that only one party, one side, chooses the arbitrator. For instance, you set up an agreement that says that we will resolve every dispute through arbitration. The claimant, this party A, is the one that will choose the arbitrator. If there's even going to be a panel, it is party A that will choose it. That one same party is the one that can file a list of witnesses, is the one that can modify the arbitration. So it's so overreaching. It's tilted in favor of one party as against another. So that one party will be able to record the proceedings, but the other cannot. Usually where there's power imbalance between the contracting parties, have an arbitral clauses setting out so many terms with only one side having the power to do certain things as against the others. Again, this, if you look at certain reasoning and cases, some courts are disinclined to enforce such an arbitration clause on the basis of fraud, or that it is inoperative, or that it is invalid. And so you would want to watch it. Of course, the superpower may want to have certain his way in some of the arbitration, but it should not be so that it is overreaching. It almost disallows the other person from having an input in the dispute resolution clause, because don't forget, party autonomy is at the heart of arbitration, and it's that both parties negotiate and come up with a process that is mutually beneficial to them. Now, I am looking at also other clauses which I've seen in, I've come across in the course of my teaching and practice. I see most agreements now stating, for instance, any dispute arising out of this agreement shall be resolved through arbitration in accordance accordance with Arbitration Act 1960. And then sometimes the clause will add or any other such law that may be in existence at the time of the dispute. Just to announce to all of you, particularly in Ghana here, that the Arbitration Act has been repealed by the Alternative Dispute Resolution Act. I mean, just for, of course, every court may interpret this to mean that the ADR Act now will apply, but just to say that now in drafting it, all those who have agreements still stating that the Arbitration Act, Act 38, will be applicable has now been repealed, and the existing law now is the Alternative Dispute Resolution Act 2010, Act 798. Now again, this other clause that I usually see, people who know that the ADR Act is now the regulating act will have in their agreement, any dispute arising out of this agreement shall be resolved through arbitration in accordance with the Alternative Dispute Resolution Act. Now here I want to point out that this clause is defective in the sense that even though you have chosen, the parties have chosen to use the arbitration rules under the ADR Act, they have not determined whether they will use an arbitral institution or they'll go ad hoc. This may be interpreted to mean that it is an ad hoc arbitration. It doesn't necessarily also mean that the ADR Center provided under Act 798 is the institution that will regulate the arbitration proceedings. Let me even mention now that even the ADR Center under Act 798 is even not in existence. So by no stretch of imagination can this clause be deemed to mean that the ADR Center is the applicable institution to supervise the arbitration, because the ADR Center, I repeat, under Act 798 has not yet been set up. So even though you may agree that your dispute should be resolved in accordance with the rules under the ADR Act, you may decide expressly if you want to go ad hoc or through an arbitral institution. Here, let me take the opportunity to talk a little bit about the advantages of both. If you choose ad hoc arbitration, of course, some have argued that you wean yourself off the cost of running your arbitration through arbitral institution. But then what it means is that parties may have to be specific on who will be the arbitrator, who will appoint what we call the appointing authority of the arbitrator, so that in situations where an arbitrator dies or perhaps resigns, decide not to move on, who do you go back then? Now, the converse is that if you choose an arbitral institution like the ADR Center, the Ghana Arbitration Center, MCIArb, etc., their rules make provision for some of these situations which may not be foreseen. So issues of language, who reappoint, etc., are all dealt with under an arbitral institution. So I made this checklist mostly for people who would want to use ad hoc arbitration. Again, because if you decide that you're going to have your arbitration through an arbitral institution, almost all arbitral institutions that I've seen have made very cogent, thorough provisions for who to appoint arbitrator, how many, if parties cannot agree, if you cannot agree on the seat, usually they end up giving that power to the arbitral tribunal or the sole arbitrator to determine issues like language, who to appoint, whether multi-parties can bring other parties can join the arbitration, whether the arbitration proceedings can be consolidated, because there's another one rising out of the same agreement. So I made this checklist specifically with focus on persons who would choose ad hoc arbitration. It is also possible that you would decide, even at ad hoc, during the ad hoc arbitration, to use, let's say, the ancestral rules to regulate the arbitration proceedings. But then again, you have to be specific then that who will be the appointing authority, especially in the case of ad hoc, such an ad hoc arbitration using those ancestral rules. Other than that, if you read the ancestral rules carefully, you realize that that decision will be then given to the arbitral tribunal so to decide. So in conclusion, what are some of the checklists before I come to the recommended clauses for recommended arbitration clauses? You need to have a checklist that have I ensured that this arbitration clause specifically says that we shall go to arbitration and nothing else. Of course, there can be multi-tier dispute resolution clauses. One will say we'll first start with mediation, and if mediation fails before we come to arbitration. But at every point in time, there should not be ambiguity as to which one is exclusive to the other. You also want to decide on whether you want to use an ad hoc arbitration as part of drafting your arbitration clause, or you want to use any of the arbitral institutions that are bound. The scope of the arbitration clause. Is it your desire that the arbitration clause will cover all disputes arising out of the agreement, or you want to limit the arbitration clause to a specific part of the contract agreement? If your intention is the former, then you have to make it clear, because the jurisdiction of the sole arbitrator or the arbitral tribunal is dependent on the scope of the arbitration clause. If you're saying that he can, for instance, give an award, but the arbitrator cannot give punitive damages, it means that if he does that, the arbitrator or the arbitral tribunal have acted out of their jurisdiction. So the scope of the arbitration clause, what kind of disputes do you want the arbitration clause to cover? The number of disputes, do you want to be specific? Do you want one? Of course, someone asked me, how about two? You can't have two arbitrators, because the nature of arbitration is that there has to be, it's like akin to a judge, there has to be a majority or unanimous. So you can't have two and then one is given an award on a different tangent. And then you also want to be sure with the applicable law governing the arbitration itself, so that you can decide to set up a different law regarding the seat of arbitration, the law that will be applicable in terms of any procedural challenges. You also want to determine the substantive law that applies to the arbitration itself. I've talked about language. And again, I mentioned that if you read other articles on drafting arbitration clause, you realize that most made reference to pre-arbitral institutions when they are bound arbitral institutions. Currently, most arbitral institutions have made provision through the arbitration rules for some of these challenges, so that parties where there is a disagreement, the default provision in that arbitral institution rules will prevail. And therefore, the caveat to that is that before you decide to choose an arbitral institution, be sure that you know the arbitration rules of that arbitral institution. They are not the same. And you want to be comfortable that the rules governing that arbitration proceedings are what the contracting parties envisage. That said, and wrapping up, I have here the doing it right, or what I call doing it right, or recommended clauses. Again, most arbitral institutions, if you go to their website, if you access the arbitration rules, they have template arbitration clauses. Again, the caveat is that do not take those templates hook, line, and sinker. But always my take home has been that as you draft the arbitration clause, step back and ask yourself, in the event of a dispute, what are some of the challenges that are likely to happen? If you do not agree, what is the way forward? And then you tidy up those disagreements. But of course, those who have chosen arbitral institutions are rather much more comfortable, because even in the event of a disagreement on a particular procedural issue, then the arbitral institution will resolve it based on the circumstance of each case with equitable principles, etc. So let's look at some of the recommended clauses. I have here, any dispute arising out of or relating to this contract or the breach thereof shall be finally resolved by arbitration. Now, this issue about finally resolved by arbitration, brings up the interpretation where in some jurisdictions, especially on issues of enforcement, arbitration may be final and binding in some jurisdiction and may not. Some parties would want to state specifically that the arbitration clause is final and is binding on parties. That's why we have this provision there. So shall be finally resolved by arbitration administered by the Ghana ADR Hub under its arbitration rules. So this has done away with the sin of omission, where you said we're going to arbitration just like that. But here parties are saying that we're going to arbitration, we are using an arbitral institution, which is the Ghana ADR Hub, and we undertake to be bound by their arbitration rules, so that leaving them with the trouble of listing out what is the language, unless they want to have a language provision or a method of appointment of the tribunal different from what the ADR Hub rules provide. And the award rendered by the parties may be entered in any court having jurisdiction. The arbitration will be conducted in the English language. There shall be 3 arbitrators appointed in accordance with the Ghana ADR arbitration rules. Finally, the seat of arbitration shall be Accra, Ghana. So this is a basic clause, one of the clauses that you can adopt to suit yourself. Of course, the arbitration rules of Ghana ADR have there for other issues that you may not have agreed on, like consolidation, like multi-party. Another thing, again, for purposes of even domestic and international arbitration I wish to talk about is if you wish for affiliates of the contracting parties to be made even parties to arbitration, let's say between a subsidiary and a parent company, or what we call alter egos of other companies, these issues may come up. And specifically for those in Ghana, there's still a gray area. If you want such parties, affiliates of such parties, to be bound by the arbitration agreement, you would usually want to have perhaps a clause in your contract that says that in this agreement, party refers to the company A, including its affiliates and subsidiaries, etc. So, and in a way that says that so that they shall be bound as if they had appended their signature to this arbitration clause. Now, a second and final example. That's a second example is any dispute arising out of this contract or the breach thereof that cannot be resolved by mediation within 30 days shall be finally resolved by arbitration administered by the Ghana ADR Hub under its arbitration rules. Again, these parties have resorted to an arbitral institutions. What it means is that they have and they should study what the Ghana ADR arbitration rule says on language, on the law, governing law, the procedural law, etc., etc. So to play it safe, they're saying that we submit totally to the arbitration rules of the Ghana ADR Hub unless we want to change it. So I guess, again, one thing for international arbitration is where there's multi-party arbitration, you want to consider issues. Again, arbitral institutions have rules on multi-arbitration, when multi-arbitration arbitration is commenced, who to appoint the arbitrator, etc. To take yourself out of the trouble, you may resort to the institutional rules on multi-party arbitration. Sometimes there'll be the need to even have a waiver of sovereign immunity, for instance, in commercial agreements, investor agreements between a state agency or a state and a foreigner, a foreign investor, for instance. So what am I saying? I'm saying that depending on the agreement involved, you would want to adjust the recommended clause to suit the needs of the particular contracting parties. That said, let me thank you. I think I'll wait for questions, but I'll leave you with a conclusion that drafting an effective ADR agreement is the first step on the road to a successful dispute resolution. Thank you very much.